for joining us on Student Docs. I'm your host, Carole Adrienne, and today we really have an exciting show which is relevant to every creative member of our audience out there, not just filmmakers, but painters, graphic artists, musicians, writers. When you create an original piece of work, that is your intellectual property. And so we're going to talk about how you keep your intellectual property yours and how to deal with it when you'd like to include other people's intellectual property in work that you're creating. So I am thrilled today. Our guest is Professor Cynthia Dahl. She is the director of the University of Pennsylvania School of Law, Detkin Intellectual Property and Technology Legal Clinic. I think that was all of it, was it? Hi, Cindy.
Hi, it's so lovely to be here.
Thank you so much. So we're going to throw some questions at you. The clinic was a tremendous help to me. I met Cynthia and her students a few years ago. You can apply online for pro bono assistance with what you're working on having to do with your intellectual property. And my documentary series, Civil War Medicine, that's in production, Cynthia and the students did my releases, my contracts, so I feel really confident that our work is all protected. So my first other guest today is an athlete and an artist, Giovanni DeSimone. Gio, thank you for joining us. Can you tell us what it is you're studying now?
In school, I'm studying digital design, where you would try to get something and make it like a sneaker. You would get like a plain white sneaker and put stuff on it to make it like a brand of something, like a TV show or a movie. Like
a logo, okay. And in a few years, when you're playing for the NFL in the off season, what kind of stuff are you going to be designing?
I would like to maybe one day design a pair of shoes or a couple pair of shoes, so something like that.
That's pretty cool. And you were talking about patterns on clothing and logos and And G is actually working on a new title slide for our show that we're going to be using in the fall. So what is your question for Professor Dahl?
I wanted to ask you, what can I do to protect my artwork from copyright, like the front cover or stuff on shoes or clothing?
Great question. There's a lot in there. And so let me just quickly try to unpack this. Okay. So one thing you talked about was designing actual shoes someday. And I know that that's not really the question you're asking right now, but I just wanted to say it's really hard to protect actual clothing, like the design of clothing or the design of shoes, under copyright. But what we can do is if you invent a sneaker that's special in some way, we might protect that in a different way, like under patent. And what we can protect under copyright is what you would stamp on the shoe. So if it's ornamental, right, and it can be taken sort of apart from the shoe, maybe that you could hang it on the wall if you wanted to frame it, like a cool logo, for example, or a design, that you can protect. And you can protect it through either copyright or potentially trademark. So copyright protects the artwork. And I think that's really behind the question that you're asking. We can also talk about trademark in a second if you're interested about like marketing and branding, but protecting the actual design is, I think, your question. Is that right?
Yep.
Okay.
Yeah, that's right.
Okay. So it is potentially protectable by copyright. And the good news for you actually is that just because you have created it and put it in a fixed manner of expression, like you've written it down, you've put it on paper or put it on a shoe, it's already protected. And that's good news. You own that copyright. Now, if you wanted to make sure that anyone else didn't infringe your copyright, then you would have to take an extra step and you would register that copyright with the government, with the US government, with the Copyright Office. And there's a procedure. It's not that expensive, but you can actually send a copy of that picture to the Copyright Office and you could protect it as a pictorial, graphic, or sculptural work, which is what this is.
Okay.
So if he put a design on a shoe and then saw somebody walking down the street with that same design on a t-shirt, that's a problem. But because he put it in a tangible form, it's really copyrighted without going through the registration process?
He has some rights to it. Now, if he wants to actually go to court, he needs to get that registration as well. But just because he committed it to a tangible form like that, a fixed tangible form, he can write that person a letter, or he can chase after them on the street and he can say, hey, that artwork is mine. And I can show you that it's mine because I did it. I did it first. And here I did it first. And hopefully there's a deterrence factor in that, where they can say, okay, I realize I ripped you off. So sorry. But if you actually need to take it to court, you actually do need to file that paperwork with the government. So that's the sort of thing the clinic helps with.
Oh. We are going to put the URL for the Copyright Office up at the end of the show, so you can go to their website and check out what the parameters are for applying for that. But that's important stuff. So anything you do, it's a good idea to register it or have it in a tangible form. You just need proof, right, that you did it.
Yes. And I understand that most early stage entrepreneurs are not going to copyright everything that they create. It's expensive. You don't have money. You're trying to spend money on other things. So maybe you can be strategic about the things that you actually register and copyright, like your most important artwork, or maybe something that you hope to sell to someone else, or a license. We can talk more about licenses in a second too. But basically, you can sort of pick and choose. It's not that expensive, but it can add up. And I understand that you're so talented, you probably have a lot of designs that you might want to protect. So
he does. He's gifted in both areas, sports and art. So, wow. Well, so speaking of putting things in a tangible form, another guest we have is Gabe Castro, and Gabe is with PhillyCam, which is one of our sister public access cable stations in the city of Philadelphia. And Gabe, I hope I get this right, you are the community media coordinator? And
I'm the programming and production coordinator.
Programming and production. Oh, I'm sorry.
That's fine.
And she is also multi-talented. So Gabe has scripts, productions, all kinds of original work. And she has some questions for Professor Dahl too. Go, Gabe.
Thanks. Yeah. So in my line of work of just helping, local Philadelphians create content, a question that often comes up is how to implement other people's work in their own work. So if they have a documentary and they want to use images, or if they have an intro and they want to use a certain song, what are the steps to kind of securing that and making sure they're, not doing what that person would be doing, wearing the shirt, with someone else's work on it, to make sure that they're attributing it properly, protecting themselves, but also, giving back and giving the right attention to the person who did create that work.
Great question. So nobody wants to be chased down the street, right? Saying, hey, that's mine. Okay. So first thing I'd like to say is let's separate attribution from protecting yourself against infringement, because you can still infringe even if you say where you got the source material from. And I know that that's different from when a lot of students are writing research papers or things like that. If you read an article and you cite, you quote the article, as long as you attribute it so that you're not plagiarizing, you're good to go. But that's not the same in law. You can say, I got this song from Beyonce, and Beyonce's still going to be mad at you because Beyonce has legal rights to control what happens to her song. So let's take attribution completely out of there. Okay. It's good to attribute, but you also need to take some other additional steps. So what's so interesting about the question that you asked is that in a documentary film, you're incorporating all kinds of cool stuff, right? You've got music, you might have somebody's name, you might have somebody's movie clip, you might quote something that they wrote in a book, and all of these things are copyrighted because back to tangible fixed expression, right? They're all put into a tangible medium. And probably somebody sophisticated has filed for copyright registration. So depending on what you want to use, the rules are a little bit different. And I can tell you that the rules with music are the most complicated. And so without going into great detail about all the things that you need to do, I would say my advice to someone that's creating a documentary is either use things that you know are in the public domain or are Creative Commons, or get permission. So let's talk about public domain and Creative Commons first. Okay, so public domain stuff is stuff that used to be copyrighted and is no longer subject to copyright. And I think Carole Adrienne knows a lot about public domain because some of the work that she's done involves things that were created a very long time ago. And copyright is limited in time. And so if the copyright has run out, you are totally free to use that stuff. Now, that probably isn't relevant to a lot of things in the documentary films that you're seeing, because people might want to use, more recent songs. They're not using a hymn or something like that. That's fallen out of copyright. So that's where Creative Commons can come in. Creative Commons is a collection of images and other sorts of content that people have made available for free license. It doesn't mean that it's not licensed. There are still restrictions, like maybe you have to attribute, it to them as the source, but you can use it. And some examples of Creative Commons would be, what's the photography, the Getty Images. Getty Images has a section that is free to use. And so if you want to pull an image off of that free to use part of Getty Images, you are perfectly allowed to do that. Check out their little terms of use to make sure that if they've got like attribution clauses or the sorts of things you're abiding by that, but you're free to use it in terms of copyright. Okay, so we talked about public domain, Creative Commons, or get permission. So how do you get permission? Music, there are certain ways that you can get permission automatically by contacting, say, the music publisher, the Songwriters Association, or the recording studio. Not music, it's a little bit more complicated because you have to contact the owner directly, but try to get permission. And then of course, I guess that's if you absolutely have to use the material. If you don't have to use the material, then my recommendation would be just to create yourself, because that's the easiest way to go, right? But I understood that I'm fighting the hypo. You told me that we had to use information. So that's the long answer. But if you're going to use music, especially be careful.
Thank you.
The Library of Congress has thousands of images which are copyright free because they've lasted, is it copyright 75 years? I forget how long it lasts. But they're explicit on their website, and you can use those images. They are available and for public use.
That's a great example. There are lots of repositories like that, but the point is just to make sure that you're going to a repository that says you may use this without danger of copyright infringement.
Cool. What else you got, Gabe?
Yeah, lots of questions. One of them is because we're public access and we are this community center, a lot of our content is created kind of in like a team or crew, like people working together with a common goal. So what are some ways that, like, if there are two people who are working together on a script or working together on some like creation, how to protect both of their contributions and to ensure that if anything happens down the way where maybe there's a falling out or anything unfortunate like that, that they can still, maintain some form of like responsibility for it.
Great question, because so much art is a result of creative collaboration, bringing great minds together. And that can happen in the script context, the book context, or in the music context, especially. Like you've got a songwriter and somebody that's better at the music, and then you've got a producer. So all of this. So again, we're back to copyright realm, and the default rule is that the person that creates owns copyright. So if you collaborate together and you don't otherwise have a contract, you are joint authors. And what does this mean? This does not mean that you each own 50% or that you each own just what you contributed. It means you each own 100%. And that means that the first collaborator has 100% of the right to do what they want to do with it. And the other collaborator has 100% of the right to do what they want to do with it. Now, the only limitation is that if collaborator A makes money off of it, they owe money to collaborator B.
Oh.
Okay, so that's the default. So that is why we as lawyers recommend that before you have the falling out, that you write a contract, because you can control everything that I've just said under a contract. Who owns it, how much they own, how much they get, if it gets exploited, in a good way, it gets used. So the rights, the ownership, and the revenue you can control by contract. So my recommendation is that, as hard as it is, because you're in a room and you're creating and it's yummy and you love each other and you're all creative and the juices are flowing, that you take a moment to take a step back and say, hey, let's just talk about this. When it's successful, who owns what and how much are we going to give each other, get it in writing, and then go back to the yumminess and hope the yumminess lasts.
Wow. So you really need to create something written down is the safest way to go with a group collaboration.
100%. And you should clarify those 3 points that we were talking about. Who's going to own it? Who's got the rights to do what with it? Are there any limits on the rights? And how much money is going to flow to whichever collaborator? Because remember, even if you haven't contributed 50%, you still are a joint owner of 100% of the work. And so, for example, a producer that makes some suggestions as the song is being recorded might have a complete ownership, even though they didn't write the song, even though they didn't write the lyrics. And if that's not the result that you want, you have to be really clear with the producer, hey, we're going to just pay you, but there are no rights here. Sorry, it's just a transactional relationship, but we're not co-collaborating here.
Work for hire, which is a finite, we're hiring you to do X and we're paying you this amount. And other than that, you have no hold or ownership of the rest of the project.
Yes. Work for hire is a funny term, and it actually has a legal meaning, but people throw it around a lot, and that's what you might hear. And that's what most people think when they hear work for hire. I would just say contract to say, we're giving you $100. Here's what you're going to do for us. No rights are going to pass. We own it.
Oh, yeah. Important. Wow. You have one more, Gabe. What else were you thinking?
Yeah, I have an interesting question because it comes up often, and I've done my own research and generally tell people, no, you can't do it. But I want to, have this to back up. Is that I often get the question about parody and what falls under parody, and what because oftentimes people are like, oh, I'm using this song, but I'm changing the words, or I'm, making I'm SNL in a way, right? So what exactly falls under parody and what can count as that? And is there extra steps in order to be counted as a parody?
Another good question. Okay. Back in copyright, we were talking about infringement when basically you use somebody else's work in a way that they did not yet authorize. There is a carve out to copyright infringement that we call fair use. And I think that's behind your question. parody is an example of fair use. There are other examples of fair use as well. Like if you're doing a commentary on something, there are a few sections of fair use, but let's just focus on the one you asked about. So parody is a defense to copyright infringement, but there's a caution here because you only get into the defense if somebody claims that you've infringed. And if you're talking about fair use, it means you're in court and nobody wants to get in court. Okay, so be very, very careful when you're relying on fair use because you don't want to have to ever claim fair use. You want it to just be free and clear. So back to your prior question about getting rights, safest thing to do is just make sure that you're not infringing at all. And then you don't even have to defend yourself. But if you do have to talk about fair use, parody is when you are making a joke of somebody else's content and you have to use the content in order to set up the joke. So, for example, there was a famous case where there was a jean manufacturer like 20 or 30 years ago called Jordache jeans. I don't even think they make jeans anymore, but they were famous at the time. I really needed a pair of Jordache jeans when I was 11. So that's how long ago it was. There was another company that decided that they wanted to sell jeans for larger sized women, and they wanted it to be a joke that the people that bought the jeans were in on, and they wanted to call them lard ash jeans. Okay.
Gotcha.
That's a perfect example of a parody, right? They're not trying to confuse the public and say like, oh, all of a sudden Jordache has decided to change their name to Lard Ash. Of course they didn't change their name. It's a joke, right? So that's parody. Parody comes up in copyright and comes up in trademark. That's actually a trademark case, but I think it's a good case to sort of talk about what parody is about. So if you decide that you want to use somebody else's copyrighted content, either a trademark or a copyright, for parody purposes, there are certain ways that you can strengthen your argument. First, you want to make sure that it's transformative, that basically you're not just copying their content, but you're moving the content into a direction to show that it is a joke or we are creating something new. Okay, that's the first thing. You only want to use as much of the other person's copyrighted content or trademark content as you need to provide the parody. It's better for you if it's a non-commercial use. If you're making money off of it, that weakens your argument. So if it's a non-commercial use, that's better for you as a person that's trying to rely on fair use. And finally, they're going to look at the market and whether or not you basically take over this, you stole money from the person that you are taking content from. If it looks like what you're doing competes with what they're doing and goes after the same consumers, that's bad for you. You want to make sure it's a different market and you're not taking money from them. So, but I guess I would back up and just reiterate, you don't want to be in the situation where you have to call in a lawyer and try to make these arguments. You want to be really careful. But this is not to say lawyers get a bad rap for not having a sense of humor. So I don't want to say, don't create funny content, but just be very careful and try to rely on being really transformative, using a little bit of it and not interfering with the market for the other person.
That's super helpful.
We have a couple minutes left, and so I'm going to squeak in my question, if you don't mind.
Sure.
I've been wondering, I know that even if it's perfect, I cannot use a Billie Eilish song in a documentary that I'm doing. However, how come I can go on TikTok and dance to it?
So the actual answer is you can't. You're not supposed to. And probably what's happening there is they haven't caught you yet. So what we're seeing again and again with digital distribution of copyrighted content is there is a tug of war going on. Maybe a better way to say it is it's whack-a-mole. Have you ever played that game? Okay. So there are thousands and thousands and thousands of people that are infringing content every day. And we're getting, the companies that own the content are getting better at recognizing when infringement is happening. because they're able to mechanize it. Now we've got computer programs that can crawl the web, for example, and find an infringing, photograph. Or Facebook, for example, is pretty good at finding, if you're uploading something that is infringement. They're pretty good at pulling it down. Mm-hmm. TikTok, I went online and looked at one point at their terms of use. And they do say in bold terms, you are not allowed to use copyrighted content in your TikTok. And I've heard urban legend is that they will either mute that song in the background, or they will not allow you to upload your video that has Billie Eilish behind you at all. But what could be happening here is maybe you're getting by the filters, and maybe Billie Eilish is not finding you, or Billie Eilish doesn't care. Because Billie Eilish might like the fact that happy people are dancing to a Billie Eilish song. And that's another thing to sort of think about here, which is that, yeah, we can have legal rules, but there's a business reality here. Mm-hmm. And sometimes it behooves you not to stop infringing conduct because your song is getting some play or your trademark is getting out there. And I don't know if you saw this in the past, but Starbucks is pretty good about shutting down sort of infringing uses of their trademarks. But they got a huge backlash and it went viral basically because their lawyers were a little too heavy-handed. And so you want to be very careful as a company to pick your battles and to be kind, to be direct, but not to really shut down your fan base or alienate your customers because, there could be some, business benefit to you having just a little bit of infringement out there that you don't shut down. So that could be what's happening too.
Wow. That is terrific knowledge. I think we're always better going into a project having some idea of those parameters so we stay out of trouble as much as possible. Well, you can go online and find the Detkin IP clinic at University of Pennsylvania and learn more about it. We're going to put up the address for the U.S. Copyright Office, and we hope that all of your work stays protected and no one steals your designs and puts them on their own T-shirts, even if that's a compliment. But thank you all so much, Cindy, Gabe, Giovanni. I really, really appreciate your coming on today, and I can't wait to see what you guys come up with next. So please join us next time on Student Docs.
Thanks, Carole Adrienne.
Thank you.
Thanks, bye.